Your limited partnership or LLC, we could go back to the operating agreement of the LLC or the partnership agreement of the family limited partnership and add a simple little paragraph that says, in essence, Mike Koval owns an interest in XYZ Family Limited Partnership. Upon his death, all of his rights and interest we want to go to, and there's a blank line. And you fill the blank line in, don't leave it blank. But as long as there's clear succession, and it could go to his children collectively, all of his 47 kids. How many? My it could go to his son, it could go to his wife, it could go to the revocable living trust. And as long as we've got that and it's signed and notarized, then your interest in that limited partnership or LLC are going to pass without going through probate. Designating a successor to your ownership of both the corporation and the limited partnership avoids those interests going through probate. Here's the problem. If you go to any Secretary of State and tell them you want to set up a family limited partnership, they're going to scratch their heads and go, we don't know, we don't have family limited partnerships. But they all have limited partnerships. The family is just a designation to say it's owned by family members. But it's not a family limited partnership technically. It's a limited partnership owned by family members. So go, and there will be on the Secretary of State, Connecticut's, there'll be a certificate of limited partnership. Fill that out, and then the agreement that you're going to sign afterwards is going to designate who owns it. But you're absolutely right. The Secretary of State does not know what a family limited partnership is, but they do know what limited partnerships are.
And what happens if distributions, Don, don't come out for years and years and years? What happens to the winner of that lawsuit?
If I prove my argument, will give me your interest in the limited partnership, or I'm sorry, in the LLC. Because there was only a single member. Some states allow foreclosure if the lien is not being satisfied after 2 or 3 years. If they don't think that you're going to distribute within a reasonable amount of time, they're going to ask for you to foreclose. They ask the courts to foreclose on your interest. And so what we're doing is we're separating the assets from each other. We're tying everything down to your trust. In this case, we would tax the corporation as a C Corp. The holding companies we would tax as partnerships. The single member LLCs don't file tax returns. Everything would come, all the taxable events would come into that real estate holding company. So we could have hundreds of real estate and still with only 3 tax returns, one for each partnership, one for the corporation. It's really a beautiful way to simplify your taxes. And then the revocable living trust, of course, is a disregarded entity as well. It doesn't have a tax return.